All right, so what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody.
This case opens with a quiet plea, but beneath the calm lies a deeply disturbing reality. Meet Alfredo Campos, a man standing before the court on a felony assault charge, but this isn't his first time. The judge doesn't just see a file number, she sees a pattern. Alfredo is accused of assaulting the very woman who showed him mercy, picking him up from custody and welcoming him home, only to allegedly be beaten and choked. This courtroom moment is more than sentencing. It's a raw confrontation between justice and betrayal. The charge? Assault of a household member with a prior. The stakes? Years in prison, a no-contact order, and the loss of custodial rights. But there's a twist. Despite visible injuries, the victim has filed an affidavit of non-prosecution. Why would a woman, bruised and black-eyed, ask the court not to punish the man accused of hurting her? Buckle up, because this judge is about to dig deep, and by the end of this video, she'll issue a sentence and some brutally honest life advice he'll never forget.
Alfredo Campos, is this a plea?
Yes, Your Honor.
All right, can I have a file stamp for a plea, please? Court is calling 2025 CR 002720 State versus Alfredo Campos. Could I have parties announced?
For the state of Texas. Renee Munoz on behalf of Mr. Campos.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Is there an application?
No, Your Honor.
All right. Mr. Campos, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, state will proceeding. Additionally, Your Honor, state will waive the repeat offender enhancement. Also no objection.
Okay. All right, did you review the document entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, in count 2, you're charged with assault family household member with a previous conviction. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
What we're hearing here is the full breakdown of rights that Alfredo is voluntarily giving up to enter this plea. Right to a jury? Gone. Right to confront witnesses? Waive. And perhaps most crucially, the right to remain silent evaporates the moment the court accepts the plea. Notice how calm and compliant Alfredo seems. But don't mistake silence for innocence. This is part of the legal choreography, and it's critical. Judges ask these questions not just for formality, but to cement the record. Now, let's hear from you. If someone pleaded guilty after a previous conviction and serious allegations like this, do you think a plea deal is too lenient? Or justified based on the victim's wishes? Drop your thoughts in the comments. This one's bound to divide opinions.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 2. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor. I did mention when you get to the stipulation.
Right. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And you're not allowed to be designated as primary custodial parent.
Yes, sir.
Right. Knowing that, do you still wish to continue with this plea?
Yes.
Right. Did you review the waiver of appeal paragraph with your attorney?
Yes, sir.
Did you understand it and sign it in both places? Did you understand it and sign it
Yes.
in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, sir.
Then to the offenses charged, how do you plea in count two? Guilty, not guilty, or no contest? State any evidence?
This time state the evidence, states exhibit 1 with all attachments.
No objection.
Right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court follow the negotiated plea bargain agreement, Your Honor.
This is where things turn. The judge isn't reading off a docket anymore. She's intervening. And she's furious. Imagine the betrayal. A woman picks you up from jail, possibly spending money meant for her kids, and you repay her by allegedly choking her. The judge sees this not just as a legal violation, but a moral failure. And when Alfredo coldly says, "I don't love her," that's the moment everything crystallizes. The judge isn't just sentencing a man, she's trying to shake a cycle of abuse, dependency, and silence. What do you think? Is this judge crossing a line by getting personal, or is she finally saying what no one else will?
All right, so what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody when maybe she should just let you stay in there, for whatever, and let you just stay there. She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. What's your issue?
I think you should.
Yeah, I mean, you do. Because somebody who, do you love her, or do you claim to love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children, to pay to bond you out, and then, all right, let me tell you what's in the police report, and you tell me what's incorrect about this. I asked victim what happened. Victim stated the following events occurred. Since Wednesday, she went to pick you up from the jail. She stated they were good, no problems. Later that day is when the defendant began to strike and choke the victim. So this is where we are.
All right, I don't know if, I think he just got a little bit tangled up. I don't know if he bonded out or if he was just released at that point, and then she picked him up instead of the bond. I think that's where he was a little confused.
I was just confused because I was released from ISF, not from the county jail.
Oh, okay, so there was no bond posted. Okay, that's what I think he was
So
confused.
here's my question. Is the reason for this offer because the complainant does not want to participate and has filed an affidavit of non-prosecution? All right. So she's filed an affidavit of non-prosecution, even though I'm looking at the photos, she has a black eye, she has bruises on her arms, and she took time out of her busy schedule to come pick you up from wherever you're incarcerated. So for some reason, she's attached herself to you, but I'm going to try to break that cycle today.
And there it is, 3 years in prison, a $1,500 fine, and one of the strongest no-contact orders we've seen. But here's what makes this moment especially powerful. The judge acknowledges the victim's decision to file an affidavit of non-prosecution and still chooses to enforce accountability. Let's be clear, victims recanting or refusing to testify is incredibly common in domestic abuse cases. But photos, police reports, and visible injuries tell a story that the court can't ignore. This ruling sends a message, one that transcends the courtroom. Should a judge override a victim's wishes in cases like this? Or is protecting the victim from future harm the highest form of justice? Let us know your take. This one's complicated.
So I'm going to sentence you to 3 years in prison. There'll be credit for any time served. There's a $1,500 fine. Time and money is not running concurrently. There's an affirmative finding of family violence. There's to be no contact with Ana Maria Hermio, aka Ana Maria Gonzalez, and you're not allowed to reside in any residence with minors. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed this plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing. Don't get involved in any other relationship. Don't contact her. If you love her, the best thing you can do for her is not contact her, because you're not any good for her. And until you figure out why you feel the need to put your hands on people in anger, you should not be in anybody's relationship. Here's my advice to you. Get an orchid. I always tell people that, and this is why I tell people to get an orchid. An orchid takes a lot of patience. When you get it from the store, it's beautiful. They all have them all with the flowers bloomed on it. They will give you directions. Those directions don't work. I learned you're not supposed to put ice cubes in them. But if you can let the blooms fall off of that orchid and keep that same orchid and get it to rebloom, you may be ready for a relationship, because with orchids, you have to learn patience. You understand?
In the end, Alfredo Compost received more than just a prison sentence. He got a wake-up call. 3 years behind bars, barred from owning weapons, stripped of custodial rights, and a lifetime reminder that violence has consequences. But what stood out most wasn't the sentencing, it was the judge's final words. Her metaphor about the orchid wasn't just poetic, it was a challenge. Learn patience and trust. Grow or stay alone. This courtroom wasn't just about guilt, it was about transformation. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll be watching the justice system, so you don't have to miss a moment.